went to the Eli Lilly versus Mochi hearing, it was quite entertaining for the future of compounding and all of these hundreds of lawsuits that Eli Lilly has out right now. And about 90% of the hearing was the judge asking Eli Lilly what their concrete injuries were and what the concrete facts were. It was a little rough for them, trying to set a standard going claim by claim and looking for concrete facts and concrete injuries that Eli Lilly suffered as a result of Mochi. Let's get into the juiciest bits. I'm Sabina. I make a tool called GLP-1er, and we help people compare providers with transparent pricing, sourcing, and reviews. I do content on accessibility, and that's why I was here. We all know what's happening. Eli Lilly doesn't like that compounded tirzepatide still exists and is still being produced. And they're using these lawsuits as a way to try to shut it down. Let's talk about some of the claims against Mochi. First, they were talking about if Mochi was actually personalizing their compounds or not. The judge focused in on what are the harms here? What is the concrete injury? And Eli Lilly didn't have a great example. Mochi's founder, Dr. Myra, who has a 4-year medical degree and is an MD but is not a practicing physician, they got into that. The judge wasn't having any of it. The judge did not care. The judge thought Myra was a doctor, and the judge didn't see any evidence that these were causing harms to Eli Lilly. Talked about Akeda Pharmacy, and was the pharmacy misrepresented? Or when a bunch of patients went from that pharmacy to another pharmacy, did that infringe on customization and mass compounding? The judge didn't see how a telehealth company changing compounding pharmacies had tangible, concrete injury to Eli Lilly. If a tree falls in the forest, does it harm Eli Lilly? Eli Lilly had a bunch of claims about the pharmacy and compounded medication, either 1, not being safe, or 2, not being effective. And the judge was having none of it. The burden was on Eli Lilly to prove that the medication was not safe or not effective. I'm not sure that Eli Lilly wants to do research studies on tirzepatide not being safe. We'll see. Eli Lilly felt that one of the harms was that Mochi was steering patients to compounded medication and not to Eli Lilly's drugs. And the judge was very adamant that these patients are not Eli Lilly's patients. At one point, they got into a Mochi ad that said best weight loss treatments. And Lilly's lawyers claimed that best meant most effective or most researched, and the judge wasn't having it. The judge straight up said best might mean the best treatment that that patient can afford. At one point, the judge asked, if my insurance doesn't cover it, how much does this medication cost? And she put the lawyers on the spot, and they couldn't confidently tell you how much the medication costs. One thing that Lilly was claiming was that these were their patients that Mochi was stealing by taking to compounding. But if compounding went away, does that mean that those patients will actually go buy Eli Lilly's medication? The judge thought not necessarily. They could go buy Ozempic instead. He spoke about a telehealth that does compounded medication, citing Eli Lilly's research, such as the SURMOUNT trial, and the judge did not care at all. And this was actually very surprising to me. The judge literally said it's the same active ingredient.